The whole case should be about the children first, okay? It used to be, I remember one seminar that I went to where one lawyer stood up and said, well, we have to zealously fight for our client even if that means hurting the children. I've had to videotape children, and there was 1,000 people in the room. I stood up and I said, excuse me, but there's an ethics code. And to zealously represent our client, we have to protect their children. That's the good way to protect the client, is by protecting their children. If you're hurting the children, you're hurting your client, okay? So children are first, okay? If nothing else you get out of this lecture, and if nothing else I get from coming here on these Saturdays and doing these lectures, is to teach people how to do family law correctly. And that is to put the children first, okay? Not to use the children as pawns in the litigation, and not to use them as footballs, and not for the parents to make them their friend, that they're burdening on them everything that's going on with the case. I was in a team mediation the other night on a case. The child is 6 years old. Of course the boy is calling, right? It's at night. You should have made it in the day, but it was the only time. And he's telling the child about the case. I'm like, why don't you just say you were at a meeting? You don't have to relate every detail to this child. He'll never go to sleep, and he's definitely not going to school tomorrow, okay? He was my client. But did I tell him the right way to do it? Absolutely, okay? You have a conscience when you practice family law. You have to sleep with yourself at night and the rest of your life. You want to make sure the kids are protected, okay? I had one case that was heading for a major custody battle, and I'm a good litigator, okay? I had one dream, and I saw the child as a cracked egg. It was the same little boy, by the way, a sensitive little boy. So I went to the other attorney who's used to litigating, and I said, you know what? We cannot do it this way, because this little boy won't be able to stand it. I don't care if the parents never talk to the child about it. There's one lawyer who lectures, and he compares it to a boxing match, and he says, custody, you don't get a knockout, you get a split decision, a win-win. So I say, no. If you go to a custody trial, it's like the stadium blew up, okay? So if you can, look to resolve those parenting plans. I gave you the parenting plan. They're on the worksheets on my website. Use the parenting plan. Look to resolve the children issues first if you can. Work out some type of access that is in the best interest of the children, okay? The custody standard is best interests of the children. That is the standard, best interests of the children, okay? And they will look at who has been the primary caretaker. They will look at who does what for the child. They will look at convenience for the child, where the school is, where the religious institution is, where the friends are, where the extended family is, and what parent can best meet that need. But guess what they look at the most in determining custody and parental access? Can anyone guess? What's that? Yes, but what gets counted as the factor towards he said the best interest of the child?
Who the child favors?
Well, they do look at that's a good question. That's a good response. They do look at the children's wishes, and that's becoming more and more powerful. I've given many lectures now about the children's voice in mediation and the children's voice in the process. And they will look at the children's voice. And another important area is failure to cooperate, okay? So I have one case now where I represent the father. The mother unilaterally took the child to live in Egypt. I wasn't the lawyer at the time, okay? And the court has ordered, I went to the court and I said, the father hasn't had the children here in America, and the children were living here before, and in his own home for 2 years. He had to go visit there. The mother will not give the visitation. So the court ordered the visitation for this past August, okay? Guess what happened? She never got the passports. She never complied with the visits. We sent numerous emails. We called the court. The court sternly spoke to her lawyer about it. So guess what I have to do now? I have to bring a motion to change custody, and there's a slew of case law about failure to cooperate. We could have worked out it, and child's wishes are important because the boy wants to go to school here in America. He wants to go to various schools that are here. So children's wishes, failure to cooperate, and the scenario, the primary caretaking scenario, you need to think of custody like a wheel. Who's involved in the children's after-school activities? Who's involved in the school activities? Who's involved with the religious activities, the cultural activities, holidays, who prepares the holidays? I represented one father also in a custody case where he did all the Halloween costumes. He did all the Easter eggs with the child. You know, he was very involved. And we ended up working out of joint custody. That was in a jurisdiction where they always gave to the mother, you know. But they saw how in-depth, he had created like a whole separate room. He had built like play equipment outside for the child. He had built the original room. I mean, his life was his son. So we worked out a very good joint custody, you know. We saved that case too. So that's what you do with custody. If the custody does not get resolved, then they will appoint an attorney for the child, okay? And that's an interesting area to go into if you're interested in family law and if you like children, is to represent the children in these cases. And then the attorney for the child will usually have a social worker, and they will interview the child or the children, and they're not supposed to ask them directly. Keep this in mind. Never ask a child directly, who do you want to live with, mommy or daddy? Okay? That's like splitting the child in two. You ask open-ended questions, and you try to find out what the child's world is. You want to step into the child's world, okay? Maybe what they like doing at each home, or, you know, or what's important to them. And I tell you what's very important to children, and I did not learn this in any law book, is pets, right? Where are the pets? Make sure the pets travel back and forth with the child. It's very difficult for children sometimes to go back and forth to two homes. I saw at a festival the other day one of my clients where we did work out a joint custody arrangement, and the children's eyes were like owls. It's also because of the conflict between the parents, but I was thinking to myself, these two boys are so tired, they're going back and forth every few days, you know, that this is, what happens according to Judith Wallerstein studies is that usually after a while, the child spends 70% in one home versus the other. But some kids are more resilient and they can go back and forth. Those parenting plans become crucial, okay? So it depends on the child. Obviously, a special needs child is not so simple, okay? They need more structure. They need, not every, but many. They need more rigidity. You know, if it's cerebral palsy, you have to set up an enormous amount of equipment in both homes to make each equipment wheelchair accessible. So these are the type of issues you must look at with the children. There's something called a forensic evaluation of the family. In custody litigation, they do have a psychologist who will be appointed, usually as a neutral, to interview the entire family, okay? And they will interview each parent alone and with the children, and they write a very detailed report, okay? So those reports hold a lot of weight, but they don't hold the ultimate decision. There's case law that the judges have the ultimate decision. And many people, if they don't like the report, then they're bringing in an independent evaluator who cannot see the whole family, but maybe just the client who didn't like it. So at trial, in many cases, you do have the battle of the experts. You have it with children. You also have it on financial matters, where let's say there's been 2 forensic accountants retained to determine value of business, and then they're battling it out. Sometimes we come to a compromise. That case we did the team mediation, there was 1 forensic accountant retained, and then he lowered it, so we got another forensic accountant. We had 2 forensic accountant valuations, but we worked out a number in the middle. We avoided a trial, okay? But I've had the trials go where 2 forensics are taking the stand, and the judges have to look at it, okay? So that's how you do that. Now, let's talk about, we still have alimony, also called spousal support, and we still have child support, okay? We dealt with property division, we dealt with custody. So, how do we determine these areas? In many states, there are formulas for these things, okay? In most states, there's a Child Support Standards Act. And child support in states is usually till 18 or 21. Half the states in America do have a provision that for special needs children who are not self-sufficient, there can be support past those ages, okay? I highly advocate for legislation in every state to get child support for children who are not self-sufficient with special needs past the age of 18 or 21. Because what happens is, it's not fair. You have an autistic child, and if both parents aren't contributing, it's falling on one parent. And the cost can be enormous for group homes, for tutors, for physical support, etc. Now, there is the disability law that gives support for people over 18 with disabilities, but that SSI money can be very low and not sufficient, okay? So those states that do not have this provision, like New York, should look to the states that have them and adopt such a provision in their child support laws, okay? So I advise all of you to take that to your legislators and get that. You would help a lot of children to do that. Now, what else? How do they determine the child support based on the formula? In many states, I'll just give you an example of one state, is they'll take the gross income, they look at income of both parents, but in reality, a shortcut is that they'll take the income of one parent, deduct FICA and local tax, and then multiply it by certain percentages. So in New York, they multiply by 0.17. That's for one child, that's 17%. For 2 children, it's 25. For 3 children, it's 29, okay? 4 children, it's 33%. That's your basic child support. Some people have said, well, does that include rent for the child and utilities and clothes? In most cases, yes. There are some items that are considered extra that are not in the formula that you can get more money or that you may have to give more money. What are those items? Medical. Okay? So the first thing the courts will look at is which parent has medical insurance, or both of them, and let's get the children on the medical insurance. All right? Then there are unreimbursed medical expenses. Don't forget these: dental, orthodontist, psychological, tutors, etc., behavior therapists. So all these co-pays, all these unreimbursed medicals. Some states, it's discretionary with the court, and it's pro rata according to income. So if one spouse makes 2/3, the other one makes 1/3, they might make one spouse pay 2/3, the other one pay 1/3. Another area is educational expenses. Educational expenses can include private school if there's a history of private school. It can include, and it's state by state, these things. It can include after-school activities. It can include college. You know, many times you have a little child, you don't think of putting college in the agreement, but I like to put these in the agreement because otherwise, when that time comes, there may not be a college fund set for the child, or no one has thought about it, and then the judges are litigating again. So you want to try to do this as much as possible. Doesn't mean you're going to hold up a whole settlement agreement if you can't agree about one item and you've done 90% of it. I understand how that happens. But if you can, get all these items in there, okay? Education, there may be special needs. You may have to get special tutors. Even testing, you know, the SAT testing, all of these things now. You know, they add up. So the more you list, the more chance you have of sharing those expenses. Sometimes for college, you have transportation costs, you have room and board costs, many costs. Some states, if you're paying for room and board, because the question comes up, do you have to pay child support when the child's in college? Well, the answer is yes in most states, but you can usually get a dollar for dollar credit against the room and board, okay? And of course, when you're representing a family, look for, there may be other sources for the children. There may be extended family, there may be trusts, there may be grants, there may be scholarships. So you kind of have to be their guardian and help them do their homework assignments to look for these other things, okay? Okay, that's educational expenses. Then you have child care. So child care is considered an expense that should be shared too if the primary caretaker or one of the parents or both parents are at work, looking for work, or in school. I know, children are expensive, all right? The statistics used to be that the income of the parent who had the child would go down, and the income of the one parent who did not have the child would go up, so that two people were living at a lower percent than the lifestyle during the marriage, and the other one's living higher. I do advocate looking at, a needs analysis, and also looking at a cost analysis and an entire income analysis, not just the strict formulas. And there's software to this. There's family law software that looks at this. There's the Tippin software. There's various companies, which I don't own, I don't have an interest in. But there are various family softwares that look at all this, that help do these calculations in many cases. And there's even apps now for these things too. But do your research about the law. Don't just rely on these calculators on the websites, okay? So that's how you do child support, okay? Now, there's another way to do it. If people are in mediation, they may not even bother with the formulas. They can opt out of the formula. Particularly if they're in a joint custody where they each have 50-50, it may not be fair that one party pays all the child support to the other. So a lot of times they're doing budgets for the children or categories of expenses, and they're opening up a joint account and both contributing maybe the same level or at different levels. And that does seem to be working as well. So I've seen that in certain agreements, more cooperative agreements. That's like the cooperative divorce process, okay? So that's the child support. Now we get to the spousal support or the alimony. It's a very touchy topic, okay? It's difficult to give the one you're divorcing money directly. Very touchy. So when do you get spousal or alimony support, and when is it not justified? In most cases, if the spouses are making equal money, then you're not going to get support, obviously. If one spouse has sacrificed his or her career and the other one earned most of the money and one was the primary caretaker, you will see alimony or spousal support in those cases. The issue is how much and how long. Some states, a couple states, have like an interim child support guideline or even a permanent, only a couple states, where they actually have a formula for these. I believe Pennsylvania has a formula. New York has an interim formula for spousal support. Some have an unspoken formula. New Jersey, the courts use a formula, but it's not in the statute. And the lawyers can even get a hold of the statute. The formula. So there's some unspoken formulas. So again, you need to work with a financial planner, or unless you're very good at numbers, and figure out what the expenses are for the family and how much support is needed to support the family. Sometimes it's a needs-based test, sometimes it's an income allocution test, but this becomes a big subject of debate. And then you have to put the whole piece together, okay? You have to look at the global picture. The finances on both sides after it's tax impacted. Well, if they have this much assets, maybe they need less alimony. In cases where there's enormous wealth, okay? Well, if they're getting 10 to 15 million in assets, there's a couple cases like that. I have them sometimes. Then they may not need the maintenance, right? Because they're going to have interest and dividends from those significant assets, okay? On the other hand, if there's very little assets but enormous income, they're going to need significant amount of maintenance, okay? So that's how you would do the basic divorce agreement, okay? That's when you can look at it. But marriage is an economic partnership, and unless there's a prenup, there is a sharing that goes on. And there's difficulty. The elephant in the room is the one who's earned it, has a very difficult time sometimes recognizing about giving. But others are more easy with it. So you have to look for the elephants in the room. What's blocking the negotiations? They're there. You have to see, is this a high conflict family or is this a relatively easy family? One thing I've looked at is, and I asked this at my consultation, do you have a history or do your parents have a history of resolving conflict through litigation or just working it out? In your business, do you go to court a lot? The ones who go to court a lot, they tend to want to go to court in their family case. Not all the time, but this is just based on my experience, okay? So that's how you do a divorce case, okay? I want to say a few words about post-divorce, and I want to say a few words about same-sex marriage. Post-divorce is another whole area of family law. So we have pre-divorce, which is the marriage. We have pre-marriage, which is the prenuptial. Then we may have breakups, which involve separation agreements, marital agreements, controlled separations, and divorce agreements. And then we have post-divorce issues. Many jurisdictions now are setting up special parts just for post-divorce issues, okay? They're also setting up special parts for domestic violence. So they're creating separate parts where divorces with domestic violence are heard separately, okay? Domestic violence can happen at any stage. If you feel or your client needs an order of protection, then you must go for that order of protection. You do not want your client to get hurt again, okay? And there is malpractice, so you really have to think about what your client needs if there's any violence. You have to think of protective ways to stop the verbal abuse and physical abuse, okay? Even if it's sometimes just emails. I went to court Friday, yesterday. I went to court because there were a significant series of very abusive emails to the client and then also some unethical behavior towards me. And the judge dealt with it immediately. Immediately. Okay? So don't hesitate. I know some people say, well, if we go for orders of protection, it's going to inflame the case. But if there's a legitimate case of verbal or physical abuse, you must protect the one who's been abused. And you need to separate them, and you need to work out either with a parent coordinator, which is a new area in this area of law, and I am a parenting coordinator as well, to reduce the conflict between the parents. Maybe a parenting coordinator needs to review the emails before they get sent to each other because they're inflammatory and they involve name calling. Again, I urge you to look at that Children's Bill of Rights. Okay? Very important. So, what issues come up post-divorce, right? Post-divorce issues, modifications. You can modify child support if the income increases or decreases, if there's been a significant change in circumstance, and it was not a voluntary reduction of income. This area comes up a lot, okay? Someone retires, maybe they don't have the same income, that might be significant. But if they're just looking to get out of child support and they voluntarily reduce their income, I have to tell you, I usually take an averaging of the income for the last 5 years of marriage, and then the year that the divorce is going through, all of a sudden there's no more income. How many times have I seen that? So basically, one person said, oh, they received something from ASCAP, which is about music. They received it every year, a certain amount, $200,000 every year. This is the first year he doesn't anticipate getting that, right? Okay. Or where they said, well, I can't keep working at this pace. There may be truth to that, right? Or sometimes one of them says, I want to increase my income. Well, I have to pay more alimony, you know? Let's say you have a spouse and let's say she's been home with the kids and now she's building a career and she's worried about paying alimony. So these are the issues that come up, okay? So basically, you have to look post-divorce if there's need for any modifications, if there's an increase or decrease in support. Many times I put into the agreements clauses how we can work out the modifications. As the children get older, their wishes are even more prevalent. By the age of 14 or 15, they're deciding where they want to live. They're deciding what they want to do and how they want to do it, right? Particularly American children. So basically, there may be need for adjustments and modifications in the schedule. Maybe they can use a parent coordinator or go back to the lawyers and work it out amicably. Sometimes there are issues and there are concerns or fights about this, okay? And then it ends up in a court. So these are some of the modification issues that be dealt with. The only thing I want to say about same-sex marriage is that in many states now, marriage is legal with same-sex couples, and this is becoming more and more prevalent. However, as of this date, the federal government does not recognize same-sex marriage, okay? There's the DOMA law, which they're looking to overturn, the Defense of Marriage Act. So with same-sex couples, there are special concerns. It may be more difficult to divide retirement accounts. There may be immigration issues. So just be aware that they might have to file 2 sets of taxes, married in their state if the state recognizes same-sex, and file as single and separate for the federal return. It's very difficult for same-sex couples until same-sex marriage is recognized on a federal level. Thank you so much. I hope it was helpful. You can reach me. The website is sherrydonovan.com, SherryDonovan.com. Thank you so much.